Well, hi. Hello, friends of aviation. My name is Gary Trichter. I'm a DWI specialist. Happy to be here with you. This video is directed to pilots. If you as a pilot suffer some type of a conviction for a criminal offense, a misdemeanor, or a felony greater than a traffic ticket, you're probably going to have to go ahead and report that to the FAA in writing. And we know that because Federal Aviation Rule 61.14 says upon a conviction for a non-traffic offense, in writing you'll need to report to the FAA security branch in Oklahoma City. So let's talk about the different things that you would have to report. If you are charged with a marijuana offense, whether it be marijuana as a misdemeanor or marijuana as a felony, you'll need to report that if you're convicted. Same is true if you are convicted of possessing or selling or wrongfully holding a stimulant or a depressant or a controlled substance or drug. If you don't report it, it's worse than anything else you can do, but only if you are required to report it, and we'll talk about that in a little bit. Turning to the offense of DWI, driving while intoxicated, that is a terrible offense for pilots because it has such terrible collateral consequences that may impact upon your career as a professional pilot and your ability to fly if you're a private pilot. Now, if you are convicted of DWI, you have to report that in writing to the Security Division, to the FAA at Oklahoma City. Yes, you'll still need to report it on your medical certificate, the first medical that occurs after the conviction. On subsequent medicals, you only have to say, I already reported it, previously reported. Now, in any DWI, you have the possibility of 2 driver's license suspensions. So in the world of DWI and the world of the FAA, you have to report the conviction. And the way that Texas has set up DWI, if you are convicted, you might lose your license simply because of the conviction. If you do lose your license because of the DWI conviction, and you can lose it on a first offense from 90 days to 180 days, if you do lose it, then you'll have to report it. If the judge in his wisdom, or her wisdom, says, not a bad person, I'm not going to take that person's license, then you don't need to report it if your license is probated, unless the judge says, you Mr. Pilot, you Mrs. Pilot, I want you to take an educational alcohol class or educational drug class or a rehabilitation class. If that is a condition of probation, the FAA says you'll still need to report it even though you haven't lost your license. And just as an aside right now, if you're operating under Basic Med, if you lose your license, you lose your medical. Basic Med requires that you have a valid driver's license in order to have a Basic Med certification. Coming back to the DWI now. If during the arrest sequence your arresting officer says to you, Mr. Pilot, Miss Pilot, I want you to submit to a breath or blood test, and you say no, that will cause your license to head down a suspension track. We call that an administrative license revocation track. And you're headed for a hearing known as ALR hearings, administrative license revocation hearings. Now the officer, what the officer will do is that officer will hand you a temporary license and he will take your plastic one from you. Now that paper one, sometimes called a DIC-25, gives you the same driving privileges 24/7 as your plastic one. There is no interruption in your driving privileges. You can go anywhere, you can drive at any time. But that license is going to expire. There's a time bomb tied to it. That's 40 days. At the end of 40 days, your license automatically goes into suspension. But this DIC-25 tells you But you have a 15-day window at the very beginning to ask for a hearing. If you ask for the hearing, the 40-day ending of your license privileges does not end. In fact, it continues on through infinity unless you have a hearing and you lose your license at that hearing. So let's talk about how that works. If you make a request within 15 days, the Department of Public Safety will not suspend your license at 40 days, which means on the 41st day, on the 50th day, on the 120th day, so long as you haven't had a hearing, you don't need to do any reporting under 61.14 to the Security Division. Now, another way you can have your plastic license taken from you is if you do agree to take a breath or blood test, if the result shows a failure, that is, it shows a .08 or more, then that will cause the officer to take your plastic license, and you have the same 15 days to decide whether you want a hearing. In my opinion, it's silly not to get the hearing because it gives you additional time to drive, and it also delays any time that you might have to report to the FAA what has happened to your license. But more importantly, if you go to that hearing and you have a really good, knowledgeable, and skilled lawyer, you may not lose your license. In fact, in many of my cases, my clients do not suffer a driver's license suspension. And if they don't suffer suspension, as a pilot, Rule 61.14 does not apply. So there's no requirement that you notify the security branch of that. There's a whole lot more to be said about that. But let me come down just to the next section of 61.14, which deals with motor vehicle actions. If you have lost your license for one reason or another, and within 3 years of that same thing happening to you, then the FAA is going to require that you report that driver's license action. So if 3 years ago you had a suspension, a revocation, or a cancellation of your driver's license, and you have it happen again, you'll need to report that. And you must report this in writing within 60 days. If you happen to forget or you miscalculate and you go outside the 60 days, the FAA could suspend your license, your ratings, your certification, any authorization you have to fly or to operate an aircraft. They could suspend it because you failed to report it. The question is, do you have to report it? And the only way you're going to make that determination is to get a really good, knowledgeable lawyer who's skilled not just in DWI, but also with the FARs, the Federal Aviation Regulations, and one that's schooled in the defense of DWI. I want to suggest that you pull the FARs, specifically 61.14, if you're facing a DWI. Be sure that you read subsections A, C, D, E, and F, and particularly F, because F can be much worse by failing to report than it would be if you reported it. Generally speaking, the FAA is not going to suspend your flying privileges or revoke your flying privileges or any authorization you have to operate an aircraft on a DWI first offense, unless during the review process by your flight surgeon or in the review process by the FAA, the documents they're going to ask you to submit, it seems to suggest that you have an alcohol or drug abuse problem. If that's the case, they're going to go ahead and deny you a medical application, or they might go so far as to suspend or cancel or revoke your flying privileges. If you have a lower test score, that's not likely to happen. But the higher you are on the testing process, you may get some FAA intervention. If you have a .08 or a .09 or a .10, my experience tells me that you're likely not to have the FAA say, we're going to suspend or do anything to your license. Just don't do it again. But if you have a .15 or a .16 or a .20, you should expect that something is going to happen with the FAA, and they're going to want you to be tested and be reviewed and have some other professionals that know about alcohol and drug abuse to look at you. And that's so that you're safe in the air and everybody else that's on the ground is safe as you're flying. So what's my advice to you ultimately on this issue of 61.14? Whether you report or not depends upon what happens during the pendency of your case. If your case winds up getting dismissed, or you get a not guilty, or your case is diverted for some reason and without a conviction, you may be eligible for another statute that protects people like yourself in Texas that refers to something we call expunctions. And expunctions is where your records are destroyed, and then Texas says, all the force and power of the state of Texas, it says, we're going to give you this time machine. We're going to take you back in time before the DWI occurred, and we're going to make your life start at that time. So if you're ever asked if you had an arrest, if you're ever asked if you had a DWI, you get to say, no, it never happened. And it's not a lie because the law says it is not a lie. Now, how good is that? So if you want to know more about your rights when it comes to DWI, you want to know more about ALRs, if you want to know more about the federal aviation regulations as it pertains to having a conviction of some kind and your driving privileges and your flying privileges, call me. I'm Gary Trichter, DWI specialist, pilot, and CFI, CFII, and MEI, and I'm happy to help you. Give me a call. I'm in Houston.